So I think, Pietro, if you're in agreement, we begin this webinar on jurisdictional immunities again. Also on behalf of Pietro Franzina, who has co-organized this instant webinar with me, I welcome you all to this discussion, which touches upon the vexed question of the relationship between jurisdictional immunities of states and the individual right to access to justice in respect of international crimes and fundamental breaches of human rights. I would like, first of all, to warmly thank those who have accepted to act as speakers in this webinar at very short notice. I think it's important to have at least a first exchange on these important developments that occurred in the last few weeks as regards a saga that has started almost 20 years ago in 2004. When the Italian Court of Cassation adopted its first pronouncement in the case of Ferrini, holding that Italian courts have jurisdiction over the claims for compensation brought against Germany by Italian nationals due in connection to the treatment they suffered at the hands of Nazi forces in Italy during the war and also after deportation to Germany. The case is well known, and I would just like to pinpoint to the core developments over the last 20 years to contextualize the discussion that we are going to have today. We know that a number of other instances were brought before Italian courts after the first Ferrini judgment, but that the decision was heavily criticized, not only in Germany. I will just refer to the House of Lords pronouncement in Jones versus Saudi Arabia of 2006, where Lord Bingham criticized Ferrini as not being actually an accurate description of customary international law, and observing that one swallow does not make a rule of international law. Some further case law has maybe accepted the Ferrini perspective in recent times, but still in 2012, the International Court of Justice held in its well-known judgment in the first Germany versus Italy jurisdictional immunities case that Italy had violated its obligation to respect the immunity which the Federal Republic of Germany enjoys under international law by allowing civil claims to be brought against it based on violations of international humanitarian law committed by the German Reich, that the Italian Republic had also violated Germany's immunities by taking measures of constraint against German assets in Italy, and that also the declaration of enforceability of foreign judgments in Italy amounted to a violation of international immunities due to Germany. The International Court of Justice found that the Italian Republic had to enact appropriate legislation, or should in any case, by means of its own choice, allow for the implementation of the judgment in the Italian legal order. And indeed, at the beginning, the Italian government and legislature complied with the judgment, adopted appropriate legislation to ensure execution of the judgment, and the Italian courts also aligned themselves with the findings of the International Court of Justice. However, in 2014, the Italian Constitutional Court took a different stance, considering that I will make a very long story brief, but the Italian Constitutional Court, as is well known, considered that the implementation of the judgment and the implementation in Italy of the customary law on immunities as ascertained by the International Court of Justice would not be compatible with respect for the fundamental rights enshrined in the Italian Constitution. This brought about a whole wave of new cases and pronouncements, which have recently led to the adoption of attachment measures as against German property in Italy, and also to a step taken by the German Federal Republic, which was somehow awaited and lingered for a long time in the air. On 29th of April of this year, Germany brought before the International Court of Justice a new case alleging that Italy has failed to comply with the 2012 judgment, and also seeking provisional measures in light of the urgency to avoid attachment measures against German property from being implemented, and more specifically the sale of German property in Italy, in order to satisfy the claims of Italian nationals that are the applicants in this long series of cases pending before Italian merits courts. On the following day, and this is probably not a pure chance, the Italian government published a decree law setting up a fund through which Italy plans to provide for reparation for the claimants. It should be noted that the decree law is not final yet, is not a law. It needs to be subject to parliamentary approval before becoming a fully fledged law. Still, it's immediately applicable, and for the time being can display its effects also before Italian courts. For those of you who are interested, Pietro Franzina has kindly prepared a translation of the particular article of the decree law into English, and the translation will be posted access to the translation will be posted in the chat. You can find it there in case you are interested in having a look at it. It's a rather complex provision. Its exact implications for the disputes pending before Italian courts are not maybe fully clear, and this is certainly something we will discuss today. Actually, the adoption of the decree had some immediate effects on the proceedings pending before the ICJ. Germany promptly withdrew not the application, but at least its request for provisional measures, which is not pending any longer. And whether the new decree implies that the case is completely moot is also something that we will certainly discuss today. So this is the situation as it now stands. There are many aspects of the case and of these developments that are of interest, and I'm very glad to be able to discuss them with our speakers. I thank them already. I also I've asked them to be very brief in their presentations so as to allow for as much space as possible for discussion with the whole participants, and whoever is interested in intervening later on is welcome to do so. I will just very briefly set out the structure of the seminar. Our first speaker is Dr. Karin Oellers-Frahm of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. She will focus on the procedural aspects of the case before the ICJ, mainly, but of course, I think she has something to say also on the substantive aspects of the dispute. Thereafter, my colleague and friend Pietro Franzina of the Catholic University of the Sacred Heart in Milan will briefly present the decree law that was enacted on the 30th of April and its impact at the domestic level. Then Dr. Giorgia Berrino of the University of Modena and Reggio Emilia will discuss the impact of the judgment on the Italian case law and Italian courts. Then Professor Riccardo Pavoni of the University of Siena will address what is perhaps the most open issue, thinking in the long term and not necessarily and only in the perspective of the dispute before Italy, between Italy and Germany. Namely, what is the impact of these new developments on the law of immunities and on the overall balance between immunities and respect for fundamental rights, specifically access to justice for in case of international crimes and for victims of international crimes. And last but not least, Pierfrancesco Rossi of the Luis University in Rome will address the influence of domestic judgments on the development of international law, offering some thoughts on in the line of a reassessment of the impact of Judgment 238 of 2014 of the Italian Constitutional Court. Thereafter, the floor will be open for questions and discussion. Questions can be put either in the chat or raised orally by using the hand function. In the interest of debate that can be that is as open as possible, questions can be put also in Italian, although our working language is English, and then we will strive to translate if this is needed. Yes, maybe it's best if questions in Italian would be simply written in the chat so that we can arrange for translation more easily. Now, without further ado, I am very happy and glad to give the floor to Dr. Oellers-Frahm for her presentation. Karin, please, the floor is yours.
Thank you very much, dear Serena. And let me first of all thank you for organizing this highly actual webinar on a topic which we all feel needs finally a definitive solution and settlement. And thank you also cordially for inviting me to take an active part in it, what is in fact a great honor for me. The topic that I will analyze a little bit closer in the next 10 minutes concerns the procedural aspects and prospects of the request for the indication of provisional measures in the case brought by Germany before the International Court of Justice on 29 April. Even though the request has been withdrawn, it may not be futile to consider it and to draw the attention to critical aspects which have some relevance for the case as such, and which, under certain circumstances, which I will analyze a little bit later, may come back to the court. As is well known, the ICJ may, under Article 41 of its statute, indicate provisional measures if it considers that circumstances so require. These circumstances concern several aspects which I will shortly address with regard to the case. The first and usually most controversial question concerns jurisdiction of the court. Due to the alleged urgency of protection, the court does not have to find definitively in favor of the existence of a jurisdictional basis, but only prima facie. But this question would, in the present case, not pose any problems, because the jurisdictional basis invoked, the European Convention for the Peaceful Settlement of Disputes of 1957, is in force between the parties since 18 April 1961. It was the jurisdictional basis in the case of 2012, and it was never contested that it covers the question at stake. The second circumstance concerns the plausibility of the case. As provisional measures are designed to preserve the rights which may be adjudged on the merits, there must be at least some prospect of success on the merits of the case. This question is more complicated in the present case, because it may be asked whether this is a new case or whether it only concerns question of non-implementation of the 2012 judgment, what would lead to the dismissal of the case, because the disputed question has been settled with binding force and implementation of decisions is not a concern for the court. And that would clearly mean that the application is not plausible, so that there is no justification for provisional protection. In its application, Germany affirms that there is a new dispute with regard to the following three questions. First, whether Italian domestic courts, relying on the novel reading of the Italian constitutional law, can entertain civil claims against Germany. Second, whether Italian domestic courts can take measures of constraint based on judicial decisions rendered in violations of Germany's sovereign immunity. And third, whether there is any justification under international law for the particular measures of constraint taken against 4 German state-owned properties located at Rome. The decisive question is thus whether the judgment of 2012 has decided these questions, which refer in particular to immunity from execution. This aspect has in fact been addressed by the court in its 2012 judgment, where it stated that there exists a difference between state immunity from jurisdiction and from execution, the latter one going further than jurisdictional immunity. Without analyzing the details of immunity from execution, the court found, however, that in any case, property, state property, used for non-commercial purposes cannot be submitted to measures of constraint. As in the 2012 case, it was not contested that the Villa Bigoni, which then was concerned, served non-commercial purposes. The court did not go further into details of immunity from execution. In the present case, 4 German state-owned properties or parts thereof, Deutsches Archäologisches Institut, Goethe-Institut, Deutsches Historisches Institut, and Deutsche Schule, have already been submitted to measures of constraint, and a date for an auction for public sale has been scheduled. This constitutes, according to Germany, a violation of international law, first, as it relies on Italian judgments delivered in violation of state immunity, and second, as the property is part of non-commercial use. This is evidently a new dispute, which offers sufficient prospects of success, and thus the request fulfills the requirement of plausibility. Closely connected to the circumstance of plausibility is the one requiring that there exists a link between the measures requested and the subject matter of the claim. This aspect needs not much comment in the present case, as the subject matter concerns the finding that execution into the properties is illegal and the measures requested are aimed at preventing such execution. The last 2 circumstances that may require the indication of provisional measures concern irreparable damage and urgency, which are usually closely linked together. In the present case, the risk that the public auction of the properties will cause irreparable damage is serious, because the public auction of the properties could not be compensated otherwise, for example, by financial means. The sale of the properties or parts thereof would irreparably obstruct the functioning of the 4 institutes, and a finding in the merits of the case that the auction was illegal could not have the consequence that the situation could be restored to the status ex ante. The damage would be irreparable, as the transfer of title could not be reversed. So I think that irreparable damage is imminent. And finally, there is the question of urgency, which at the moment, 29 April, when Germany filed its application and the request for the indication of provisional measures, was clearly present, since the public auction was scheduled for May 25. But as we all know, and as Serena has just reminded us of, on 30 April, the day after the application was filed, the Italian government adopted Decreto Legge number 36, which provides in the relevant passage of Article 43 that the Italian courts are required to lift measures of enforcement previously taken, and that no further measures of constraint will be taken by Italian courts against German property used for German non-commercial purposes located on Italian territory. Furthermore, all proceedings enacted aiming at enforcement of judgments according reparation are cancelled. This passage, and Serena has mentioned this already also, this passage seems to lead to the consequence that not only there is no urgency for the indication of provisional measures, but that moreover the case as such is moot, as there is no longer a dispute to be decided upon. This situation was apparently the reason why Germany withdrew its request for the provisional measures. But why did it not withdraw also its application? The reason, therefore, is evident and plausible. The promise, if I may say so, that no reparation measures or claims would ever again be raised against Germany, and that Italy itself will satisfy the persons that have already been accorded certain amounts in binding decisions, is placed in a decreto-legge. A decreto-legge, adopted on the basis of Article 77 of the Italian Constitution, is not, if I may say so, or at least not yet, a reliable legal basis, because it has to be converted into law by Parliament within 60 days. Otherwise, it is null and void since its adoption. I will not speculate on the prospects concerning the adoption of the decreto by Parliament, but only make some general remarks as announced in the beginning. As long as the decreto-legge is not converted into law, the situation remains open, and that means that Germany was absolutely right in withdrawing at this moment only the request for the indication of provisional measures and not the application. If the decree is not converted, Germany will probably renew its request for provisional protection, and even if the decree is converted, this may not be the last word. The question may be brought to the Italian Constitutional Court, on whose reaction no speculation is allowed or possible. If the decree is converted and no further steps are taken against its contents, this would finally terminate the seemingly never-ending story of state immunity between Italy and Germany. Germany would in that situation discontinue the case and perhaps ask the court to indicate in its order for removal of the case from the list the terms and reasons for discontinuance. If the decreto is not converted into law, and if then the case continued, my impression would be that not only the request for provisional protection, but also the merits of the case would be successful, and that already simply on the basis that the four state properties are used for non-commercial purposes, a fact that Italy has already admitted in an aide-memoire of October 2021. A finding that of the court that Italy acted in violation of international law would certainly not affect the friendly relations between the two states, but would throw an unwelcome shadow on these relations. Therefore, the preferable option of discontinuance of the case due to the conversion of the decreto-legge would be a particularly welcome solution in times as those we go through actually, where the significance of settling disputes peacefully is showing up so forcefully, and peaceful interaction between states is so urgently needed. Thank you for your attention. I will leave it with this.
Thank you very much, Karin. And indeed, you raised a number of very, very pertinent points. I would also point out the fact that the Constitutional Court in 2014 did not address the issue of immunity from execution. So this is not an aspect covered by that pronouncement, at least not formally, although it has been deemed to cover, at least by implication, immunity from execution. So the problem of a new case before the Constitutional Court is something that has been discussed in literature, at least in Italy already. So that is certainly something that we can perhaps look forward to, or envisage as possible, at least. And now I will just give the floor to Pietro Franzina. We will reserve the discussion for the end of the presentations. Pietro, the floor is yours.
Thank you, Serena. So the purpose of my very quick presentation is to provide an overview of Article 43 of the Decree Law number 36 of 2022, which has already been mentioned both by Serena and by Karin. A few words on the decree itself to begin with. It's a 50-article decree which concerns the implementation of the National Recovery Plan for the pandemics. If you're confused about this, well, you're not alone. It's a bit strange to find a provision like the one we are discussing today in such a decree. I see that in the chat, a question has been raised precisely about this, the inclusion of a provision that has nothing to do with the recovery from pandemics in a decree that concerns pandemics. Well, I will get back to that probably in the discussion. Anyway, Article 43 is about claims for damages against Germany for prejudice suffered as a result of war crimes and crimes against humanity committed between 1939 and 1945 by the German Third Reich's army. Basically, the purpose of Article 43 is twofold. On the one hand, the purpose is to shield Germany from those claims, including claims that may be raised in the future. And at the same time, that's the second purpose, the idea is to ensure that those entitled to damages, in fact, receive reparation or some form of redress through a dedicated fund that is created under the provision itself, Article 43 of the Decree Law. Before I say something on the contents of Article 43, let me state or restate a few things concerning decree laws in general under the Italian Constitution. Article 77 of the Italian Constitution provides that the government may adopt measures in case of, I quote, necessity and urgency, measures that are immediately applicable, but cease to be effective if they are not converted into law by the Parliament within 60 days of the adoption of the decree law itself. The Parliament is, upon the adoption of the decree law, immediately seized of the conversion. And indeed, as it has been mentioned, the Parliament might decide not to carry out this conversion. I regard this as an event that is rather unlikely because, generally speaking, the non-conversion of a decree law involves major political implications. But what I would like to mention, since this has probably implications that are of some interest, is that the Parliament may, in converting a decree law into a law, make amendments to the decree law. So that's an option that is open to the Italian Parliament to modify the content of Article 43 when converting the decree law into law. If indeed the conversion does not occur within 60 days, then the decree law ceases to have effect and loses all effects retrospectively. As far as the contents of Article 43 are concerned, there are basically three groups of contents. This is a rather complex provision. The way in which it is worded is not as fortunate as one would like to. It's not very clearly drafted. So if you find the translation is not helpful, well, that's part my fault. Sorry for that. But to some extent, that is the fault of the government, because the wording of this provision is really not as clear as one would want to. So there are three basically groups of provisions within Article 43. The first group is about the fund that the decree law is meant to create. The second group is about judicial proceedings, including enforcement proceedings. And the third group, a tiny group, just one provision, is about the substance of the claims for damages against Germany. So to begin with, the fund. the damages covered by the fund, the damages for which redress the fund is being created, are damages suffered by victims of war crimes and crimes against humanity that were perpetrated, as I said, by the army of the Third Reich between 1939 and 1945. What is interesting is that for these damages to be eligible to benefit from the fund, they must either be committed in Italy or be committed against, that is, harming an Italian citizen. The fund is meant to benefit those who have obtained a final judgment for these damages, either in proceedings instituted before the adoption of the decree law or in the 30 days after the adoption of the decree. So, final judgment obtained in proceedings instituted before May the 31st, 2022. The fund is created under the decree, but the decree does not provide a full-fledged regulation of the functioning of the fund. That is delegated to a decree, a ministerial decree, that the Ministry of Justice has 6 months to adopt. That's a long time. The second group of provisions within Article 43 relate, as I said, to judicial proceedings. This is probably the most interesting part of Article 43. There are, to begin with, provisions relating judicial proceedings on the merits of the claims for damages I referred to earlier. These can no longer be brought after 30 days following the adoption of the decree. So judicial proceedings will be forfeited, will be regarded as inadmissible if they are brought before an Italian court after 30 days of the entry into force of the decree. Judgments concerning these claims will only become enforceable when they are final. This is by derogation of a general rule of Italian procedural law, according to which first instance judgments are provisionally enforceable. This is not the case for these particular judgments. As regards enforcement proceedings, no new enforcement proceedings shall be admitted, and existing proceedings shall be lifted and discontinued. This is about the rules relating to judicial proceedings. Finally, as far as the substance of claims for damages are concerned, a provision is included in Article 43, whereby the right to damages of the kind I've referred to earlier shall cease to exist upon the payment by the fund in accordance with the procedures that will be set out by the ministerial decree I have mentioned. That is all for now, but I'm ready to answer the questions, and I'm sure Giorgia will build upon what I've said and further clarify things. Thank you.
Thank you very much, Pietro, for this much needed illustration of the main features of the new Italian legislation, or better, decree law. Not yet legislation, as you made clear. Now, Giorgia, the floor is yours. What is the situation in Italian merits courts, and what are the implications of these developments in that context? Please.
Yes, thank you, Professor Forlati, and good morning, everyone. First of all, I would like to thank the organizers, and in particular, Professor Forlati and Professor Franzina, for the kind invitation to speak this morning. And I also would like to thank the speakers who have preceded me for the clear picture of the situation they have provided. So my task today is to offer some brief reflection on Article 43 of the Italian decree law, in particular about the reasons of its adoptions and also about its effects. So the decree passes to several initial reflections. Professor Franzina and I talked about the decree at length yesterday. In any case, I will do my best, as promised, to stay within 15 minutes for listening to the other speaker and also to the floor, who will certainly be able to respond better than me to the question that arise from the Italian decree. So let's start with the reason for the adoption of Article 33 of the Italian decree. The first reason is therefore also C, so namely the application by Germany to the International Court of Justice for violation of jurisdictional immunity. But in my opinion, there is also a second reason why Article 33 was adopted by the Italian government. The second reason is deeper than the effect of the German application to the International Court of Justice, but is closely connected to it. The reason is the fear of the Italian government that the time was ripe for the Italian judges to raise a new question of constitutional legitimacy before the Constitutional Court. So this time the question, of course, of constitutional legitimacy would have concerned the compatibility of the norm of customary international law that established the immunity of states' property from foreign measure of constraint with Article 24 of the Italian Constitution, which, as we know, provides for the right to judicial protection. So, as has been said, it's not really a coincidence that Germany, after waiting 8 long years since the Constitutional Court ruling of 2014, and from the proceedings that were held following the judgment, has only today approached the International Court of Justice. There is a very specific reason, namely the fact that these German properties, so as Karin remembered, the German Archaeological Institute, Goethe Institute, German Historical Institute, and the German School were attacked. So I would like to briefly focus on what was stated in the orders of the judges who ruled on the request for suspension of the executive action presented by Germany with respect to the aforementioned properties. Following the executive action taken against these assets, Germany immediately applied for opposition to the enforcement, with a request to suspend the enforcement on the basis of the public destination of the properties. The Court of Rome, with its order of 12 July 2021, rejected the German request, stating that the immunity of German properties from measure of constraint could not be recognized on the basis of the principle that were established by the Constitutional Court in its decision of 2014. So principles which were applied for the first time to the executive proceedings. In particular, the court clarified that if immunity from the civil jurisdiction is denied to a foreign state because the state was found responsible and convicted for acta iure imperi constituting serious violation of fundamental human rights, the execution of the judgment must always be guaranteed so that the judicial protection provided by Article 24 of the Constitution would be effective. This was an argument that was already proposed. I remember an article of Lopez Peña that talked about this specific possibility. So the court, in this case, held that the possible public destination of the properties was completely irrelevant to its decision. What happened? Then Germany decided to field a sort of appeal, technically a reclamo, against the decision, which was rejected. So the panel of the judges that heard the appeal with the order of November 3, 2021, confirmed that the execution should be not suspended. But the decision was based on a different argument than the one used by the first instance judge. Indeed, the panel of judges stated that it shared the basic principle expressed by the first instance judge, according to which the protection in the executive phase represents an essential component of the right provided by Article 24 of the Constitution, guaranteeing the effectiveness of judicial protection. In spite of that, the panel of judges also stated that this principle must be balanced by those principles established by customary and conventional international law. Therefore, according to the court, the decisive aspect of the question had to be identified in the use of the properties subject to measure of constraint, since, according to international law, property which are used or intended for use by the state for public purposes cannot be subject to measure of constraint. Nevertheless, the court held that in the present case, the public purpose of the properties had not been proven by Germany. So we can say that the different orientation expressed in the two rulings analyzed would seem to reveal the existence of two different impulses in our legal system with respect to the relationship between the constitutional right to judicial protection and the international rules on the immunity of states' property from foreign measure of constraint. Of course, in the event that the execution relates to conviction deriving from the commission by states of serious violation of fundamental human rights. Therefore, as anticipated, among the reasons that prompted the Italian government to adopt the decree law and Article 33 was also the concern that Italian judges could raise a new question of constitutional legitimacy, and the Italian Constitutional Court could possibly issue a twin judgment to the one of 2014. So now we come to the effects produced by the Italian decree. As we know, the adoption of the decree resulted in the withdrawal of Germany's request for provisional measures. However, as was noticed, the decree law has resulted in the withdrawal of the request for provisional measures, but on the other hand, it will not have the same effect on the German application, which still remains standing. The decree would seem also to sharpen the dispute with Germany in some respects. As mentioned, indeed, Article 43 also provides access to the fund for those who claim against Germany within 30 days of the decree's entry into force, and therefore within 31 May 2022. So there is a government invitation to present this action, and this invitation opens the way for further violation of the German immunity from Italian civil jurisdiction by the Italian judges. Of course, this contrasts with the request submitted by Germany to the International Court of Justice. So I quote what Lorenzo Gradoni wrote in his post of yesterday in Agile Talk. The decree law leaves the issue of immunity from jurisdiction untouched. This is indeed an area that is difficult to navigate without breaking the limits set by the Constitutional Court in 2014. So what about the internal now effect of the Italian decree? Article 43 raises a number of questions. First of all, we can start with the pending proceeding. For pending proceeding in the cognitive phase, there is the hope of the government that they can be concluded with a settlement. Paragraph 2 of Article 43 grants the possibility to conclude by settlement after consulting the state attorney any judgment pending on the date of entry into force of the decree or those established before May 31. So this settlement gives access to the fund. So several questions arise around this settlement. First of all, with whom should the plaintiff be concluding a settlement? Germany is being sued, and therefore, technically, Germany should be the one to settle with the claimants. Paragraph 2 of Article 43, as mentioned, provides the state attorney, and therefore the Italian government, must intervene but the state attorney is not technically a direct party in the settlement. So as a matter of fact, in paragraph 2, it is stated that the state attorney should be consulted as if the intervention of the state attorney is considered as having a sort of consultative nature. So now we need to explore two different hypotheses. The first hypothesis, in some cases, we know that Germany appeared in court. So in this case, will the settlement have to be concluded with Germany? Moreover, if the answer were affirmative, could such settlement entail some form of acceptance by Germany of the Italian jurisdiction? Furthermore, in this case, on what should the state attorney be consulted? Should the state attorney exercise only a role of control over the specific amount of the settlement, which would then have to be paid through the fund? Then we have a second hypothesis, in cases where Germany has not appeared in court and has been replaced by the Italian state attorney. So will the state attorney effectively take on the role of party with which the settlement should be concluded? I don't know, these are questions and we must try to identify an answer. So as already mentioned, in terms of the procedure to be established, this decree will have the effect of pushing for the activation of new cognition procedures within the deadline set by the decree. So let's analyze now very briefly the procedures in the execution phase. In this case, the existing proceedings are terminated upon the entry into force of the decree, and thus not yet established will not be able to be initiated. So consequently, the possibility of being compensating through executive action is literally eliminated. So access to the fund seems to become the only alternative. The endowment of this fund is currently foreseen for only 4 years. So this could endanger the applicant's reason, considering that it might take a very long time for the judgment on merit to become final, which today is a condition for access to the fund. Just a very brief final consideration, or rather a further question. Can the solution adopted by the Italian government be considered satisfactory? The answer may vary depending on the point of view. So let's start with the point of view of the victims. As soon as the decree was published, I received 2 phone calls from lawyers who are following some cases against Germany for the crimes of the Second World War. These lawyers were literally enthusiastic about the establishment of the fund. However, it should be noted that the fund provides a sort of indemnity for the victims, technically using the term of the decree, a ristoro, that means a payment that could be not qualified as a real compensation. So the current scope of the fund seems limited compared to the sums to which Germany has been sentenced by the courts to pay. So for the moment, the law decree provides that the fund has 20 million euros for 2023, and then almost 20 million euros, 12 million euros for each of the years from 2024 to 2026, for a total of about 55.5 million. So therefore, if the endowment of the fund is not increased in a very significant way in the future, the sums available will be insufficient to recognize a significant relief to the victims, more in line with the amount of compensation quantified by the courts. So this is particularly evident when you consider that only one of the lawyers I spoke with claims that if he considered the total compensation to which Germany was sentenced in the cases he defended, his clients would be entitled to ask for 42 million euros from Germany. problem of constitutional legitimacy could perhaps arise if the amounts of the so-called ristori, so of the indemnity, were deemed unreasonable and disproportionate to the sums identified in the judgment of the courts. Okay, there is also another point of view that must be evaluated, namely that of the more general consequences that the solution adopted by the Italian government could have. As we know, the solution of an intervention by Italy to replace Germany in the compensation of the victims of Nazi crimes had already been suggested for some time by a part of the doctrine, for example, Professor Gaia. However, another part of the doctrine has always been dubious about Italian intervention to replace Germany. For example, Professor Focarelli just recently underlined how a solution of this type would not only be peculiar, but would also constitute a sort of slippery slope argument. So I don't have the time to analyze more in depth these aspects. Maybe we can talk about this in our debate. Just to conclude, I would like to say that Article 43 of the Italian decree law finally seems to provide some relief to the Italian victims of the international crimes committed by the Third Reich, or some answer. However, its current formulation raises also a number of questions. So to identify the answer, it will be necessary, as Professor Franzina say, to wait the decree is approved in Parliament and then to wait for its first applications. Thank you very much for your attention.
Thank you very much to Dr. Giorgia Berrino for this interesting presentation. Indeed, compensation by Italy might be a slippery slope, but it's the only way through which Italy can manage to combine respect for the Constitution with respect for international law. So I think this is really the only way forward in this specific instance. But I would not like to take any more time. I give now the floor to Professor Riccardo Pavoni for his presentation on the implications of these developments on the international law of immunities. Riccardo, the floor is yours.
Thank you very much. Can you hear me? Okay, thank you so much. Thank you so much for the invitation, Serena. Thank you so much, Pietro, for having invited me, for having organized this instant webinar. We just have a few minutes to make our points, so I will try to be as brief as possible. I was supposed to say some words about the possible impact of these recent developments on the law of international of state immunity in general, and more specifically vis-a-vis its relationship with international human rights law. So the problem of the famous problem of a so-called human rights exception to state immunity. Of course, this is all these documents and materials are very recent. Everything is very fresh. So I confess that I still have to reflect more comprehensively and accurately about these developments. But so I will just give account of the few ideas that have come up to my mind in the last few days. So when discussing the impact, this kind of impacts, I think that two possible scenarios can be identified. And it has already been said in the previous discussions. I think the first scenario is that the Italian decree law, the recent Italian decree law, brings the dispute with Germany to an end, so that in the following months there will be again I think it will take a lot of time, indeed, as Karin Oellers have made clear. Of course, there is also the specter of a further challenge before the Constitutional Court. So I think it's reasonable that Germany would like to follow those developments and to see whether a constitutional challenge is raised by any Italian court. So I think that the first scenario would be that in any case, the two states will be agreed in the future that the dispute before the ICJ must be discontinued, and then that we will have finally a closure with respect to this long-standing saga relating to compensation claims for victims or brought by victims of Nazi crimes during World War II. So what that closure, if the closure indeed happens in the following months, what that would tell us about the current state of state immunity and about its relationship to human rights law. In my opinion, I've always taken the view that that international law is ready to accept limited limitation granted in human rights to state immunity, especially when the right to effective judicial protection is not guaranteed by way of alternative means of redress, when the forum state has to decline its jurisdiction in the light of state immunity. So I think that at least in this case, I mean, we're not saying a situation where state immunity is upheld and there is no alternative means whatsoever. We have an alternative means. We have a fund established by our government. Of course, we must see what happens with the further ministerial decree that Pietro was talking about, that will be adopted in the next 6 months by the Minister of Justice. We must see what the parliamentary debates about the conversion into law will say about this decree, whether any significant amendment will be brought to this Italian law decree. But if things go well, in my view, this could bring a closure to that dispute. And in that case, we could say that indeed, in this particular case, in the case of victims of Nazi crimes, whose claims were allegedly not settled before, they were allowed access to an alternative means of redress, the Nazi crimes fund. Of course, that's an alternative. The big issue which is unsettled so far is whether that alternative would be considered effective by our courts, by our authorities, and possibly whether it would be considered effective by the Constitutional Court in the case that a new challenge will be brought before the Constitutional Court. But at least as things now stand, we can say that victims have not been left without any remedy in this particular situation. So I think that that's indeed important in this area, because we do not see a situation again where state immunity is upheld and no remedy is afforded to the victims. What that would imply for the Italian case law and the Italian jurisprudence on the human rights or jus cogens exception to state immunity? Because, of course, what is very clear to everybody is that the decree law adopted by the government is not reneging on the Italian jurisprudence, is not interfering with that jurisprudence. It does not say, as the former law, which was adopted in 2013, was saying that Italian courts where certain claims adjudicated by the International Court of Justice have been brought must pronounce a decision or must decline their jurisdiction. It's not saying that. It's just targeting the specific category of claims that relate to compensation for Nazi crimes. So this decree law, of course, does not bring to an end the Italian jurisprudence, the Italian so-called Ferrini jurisprudence or 238 Italian jurisprudence. So the implications, I mean, the future of that jurisprudence is still a matter of uncertainty, because even if Germany does not continue its case before the ICJ and this saga comes to an end, of course, it's just a matter of time before another state may indeed challenge decisions taken against it by Italian courts on the basis of the Ferrino 238 Italian jurisprudence. Of course, that jurisprudence is not related to Germany exclusively. That jurisprudence clearly holds that states are not entitled to state immunity when they commit grave breaches of international law, and especially commission of international crimes. So I think it will be just a matter of time. Of course, then the problem could be whether that foreign state would have a jurisdictional basis to go before the ICJ, but that's an entirely different matter. Sooner or later, we will hear something more about the Italian jurisprudence. Of course, I'm just recalling here that it's true that I would say, unfortunately, 90% of these cases in the Italian jurisprudence relate to Nazi crimes, crimes dating back to World War II, and they very, very rarely relate to current instances of grave breaches of international law. But there are some exceptions. There is a 2015 judgment by the Italian Court of Cassation against Serbia for a crime committed during the Yugoslav wars back in the 1990s. And there is another very significant decision of last year, a few months ago, by, again, the Italian Court of Cassation, in this case against Iran, where the Italian Court of Cassation recognized a decision by a US court awarding damages against Iran for its alleged involvement in the famous attack on the Twin Towers back in 2001. So, as you can see, these are just a couple of examples to show that, of course, even if the Italo-German dispute comes to an end, that would not mean that this Italian practice will not be under the spotlight again in international law. So we will see what will happen with that Italian jurisprudence. My view is that we just need a new decision by the Italian courts stating very clearly what are the conditions of applicability of that jurisprudence, what are its limits, especially when it comes to the issue of jurisdiction. Does the jurisprudence only apply to territorial crimes, crimes committed in Italy or against Italian national, or does it have a broader scope of application? I think that has never been clarified by our courts. If the dispute with Germany does not come to an end, whether Germany is not satisfied with the conversion of the decree into law, or for other reasons of principle is not satisfied by the steps that the government will take in the next few months, then of course that means that the ICJ will have to decide again on this issue, and we have to assess and rule on Germany's claims and submissions as made by Germany, as let down by Germany in its application of the 29th of April of this year. In that particular case, I mean, of course, Germany will be free to amend its argument, its submissions, its claim, but if it will keep the current structure of its application, I would like to say a couple of words about that, because Germany says that there are 6 basic elements arising from the 2012 decision by the International Court of Justice that Germany outlines in its application. The first one is that respect for immunity, state immunity, is a matter of binding international law, not of mere comity. So it's a binding rule of international law. I think that's fair enough. I think that's correct. Of course, I would add here that there are some certain notable dissident voices here. And of course, the elephant in the room, again, is the United States practice, which is very, very different from this basic assumption which is present in the New Germany's application. That's a broader issue that we can discuss during later on. I don't want to say anything more about the United States practice in matters of state immunity because that would take a lot of time. The second submission by Germany, the second element identified by Germany in that judgment is again the problem that immunity is a rule, procedural rule, and then it's not a substantive rule. That means that it's an issue which is entirely distinct from the substantive law determining the legality of state conduct. Again, I would say, of course, that is present in 2012 judgment, but I would just to remind everybody that that is one of those arguments which is fiercely criticized by a large amount of scholarship, this saying that this distinction is in a way artificial and too legalistic. The third submission is that, according to Germany, is that under customary international law, as it presently stands, when the ICJ said this was 10 years ago, states are obliged to respect immunity of other states, even when great breaches of international law are at stake, even when Jurisdictional violations are at stake. And of course, the only quote, an exceptional quote in the application by Germany is to the European Court of Human Rights. Of course, if I was a German lawyer, I would indeed do exactly the same, highlight that the regional human rights court, the European Court of Rights, in the case that Serena already mentioned, the Jones case back in 2014, found the ICJ decision authoritative and of course decided the case in favor of the respondent state, the UK, which according to the court did not violate Article 6 of the European Convention. Of course, that's not the end of the story. There have been some developments recently. I would just like to say very, very rapidly that there have been at least a couple of decisions in the last year, which everybody has heard about. One is a Korean decision, again relating to compensation for World War II crimes against Japan in that case, and then a more recent decision by the Supreme Court of Brazil, again against Germany, and again relating to World War II. I'm not saying that those decisions are correct, that are sound. I'm just saying that those are two instances of state practice which should be considered in a new judgment in a potential new judgment by the ICJ. And the fourth submission, very, very rapidly, it's again about that, of course, which I think is the weakest part of the 2012 ICJ judgment, the part relating to the territorial tort exception. In that case, of course, Italy, the argument advanced by Italy was that those crimes were committed on Italian territory. Those crimes were covered by the territorial tort exception to state immunity. The ICJ found against Italy and said that indeed, even if that territorial tort exception was a matter of customary international law, that exception does not apply to military activities or to activities carried out in armed conflict, generally speaking. I think that that conclusion is very shaky. I think that that conclusion can be countered by many arguments. And then a final word, because I think this is very new in Germany's application. It will really bring a new element in the law of state immunity. It's about immunity from execution, immunity from measures of constraint. Because as our colleague Karin already said, Germany's arguments are twofold here. First, of course, nobody, actually, I mean, well, the first argument by Germany is that when a merits decision is unlawful because it violates state immunity, then no measure of constraint at all can be taken against property of foreign states. When states are precluded under international law from taking any measure of constraint against the property of a foreign state on the basis of a judgment that itself has been rendered in violation of the other state's sovereign immunity. The Germany's application quotes several parts of the ICJ judgments, but I must confess that I cannot find any basis whatsoever in international law for that assertion. The ICJ did not say that explicitly in the 2012 judgment, and that limitation is not included in the UN Convention on State Immunity. So really, that will really be something new if upheld by the International Court of Justice. And indeed, the subordinate argument, the other argument by Germany is the classical argument according to which state property used for non-commercial purpose, for government purposes, is covered by immunity. And of course, there can be no doubt that those scientific, cultural institutions which are the object of an attachment by the Court of Rome are indeed in use for government purposes. I would have no points against that position, and of course that position also entails that, of course, those cultural institutions owned by Germany in Italy are not fake cultural institutions, because they are indeed used for cultural governmental purposes. I'm just saying this because I would like to, because for example, in Canada, certain alleged cultural institutes owned by Iran have indeed been attached on the grounds that they were not cultural institutions. In fact, they were used for other purposes. So that is my take. I will just stop here and I will leave perhaps room for questions in the discussion. Thank you so much.
Thank you, Riccardo. Thank you very much. You highlighted a number of important aspects, including the case law of Italian courts, which is indeed not only concerning Germany, although an important element here is that Italian courts have consistently denied the idea that universal jurisdiction would apply in cases of this kind, and therefore it is only in a number of very limited situations that Italian courts have found against foreign states other than Germany in the relevant litigation. So last but not least, I now give the floor to Pierfrancesco Rossi of the Lewis University in Rome, who will deal more specifically with the impact of the Constitutional Court's judgment of 2014 on general international law. Pierfrancesco, the floor is yours. Do you?
Yes, I'm here. I'm here. I hope you can see me and hear.
Yes.
All right.
Yes.
Awesome. Thank you. Good morning. Many thanks to the organizers for having me here today. I have been asked to take on a pretty daunting task, namely to reflect on the question, where do the Italian courts go from here as far as state immunity goes? Of course, I have no idea of what the Italian courts will do, and good luck if you wish to predict that. But I'll just try to share some thoughts on what they might do and on their role in the evolution of state immunity. Let me start from a story that university students in Italy are told when they study international law. The story goes like this. Once upon a time, there was absolute immunity until the courts of Italy and Belgium initiated restrictive immunity. However oversimplified, the story is mostly true. It all happened when some courts of those two countries, for some reason, started treating suits against foreign states just like they used to treat suits against their own state. Because at that time, Italian administrative law stated that private citizens could sue the Italian state only when the state acted like a private citizen and not in the exercise of public powers. Over time, other countries adopted the same approach, and state practice changed, so did the customary norms on state immunity. So immunity law borrowed from Italian and Belgian law the distinction between public and private state acts. Professor Tesauro, who drafted Judgment 238 of 2014, knew this story very well. And you may find it narrated at paragraph 3.3 of the judgment. And where it gets even more interesting is that in this paragraph, the court drew a parallel between itself and the Italian courts that initiated restrictive immunity, stating that it wished to, I quote, also contribute to a desirable and desired by many evolution of international law. However, when we look at the current scenario, things seem to be playing out quite differently because the novel approach of the Italian courts is meeting much resistance. And this begs an obvious question: why? What is the difference between then and now? The most intuitive answer is that the key difference lies in how other states reacted. At the origins of restrictive immunity, many others followed in the footsteps of Italy and Belgium. Had they not done so, today we would be speaking not of the day Italy changed the law of state immunity, but of the day Italy violated absolute immunity. With a bit of imagination, we can picture the scene, which would look very familiar to us today. Defendant states complained, third countries voiced protests. The matter was deferred to arbitration, but Italy lost. And eventually, the Italian parliament passed a law prohibiting courts from entertaining suits against foreign states without their consent ever again. Absolute immunity wins. This is not how things went back then, but they are going pretty much this way now. I believe, however, that this intuitive answer is wrong, or at least not yet true. And the simple reason is that it's too soon to tell. The first rulings adopting restrictive immunity occurred, to the best of my knowledge, in Belgium in 1857 and in Italy in 1886. But when Romanian courts, just to name one random example, transitioned to restrictive immunity in 1920, they were still considered forerunners of a very novel trend. The US transitioned in 1952, the UK in 1975, China maybe in 10 years or 20 years, because they still apply absolute immunity in China. Thus, my point is that as far as state practice goes, our position today is not unlike that of a lawyer wondering in 1910 if restrictive immunity was just a temporary fashion. What we do know is that Judgment 238 is having some influence on other jurisdictions. A few examples were already mentioned by Riccardo Pavoni, and we also know that this influence is twofold. First, other courts have developed a humanitarian exception, let's call it this way, to immunity based on constitutional arguments. Besides Italy, we have at least Brazil and South Korea, both in 2021. There may be other cases we're not aware of. Judgment 238, by the way, was expressly cited in the Korean case law on the so-called comfort women. Second, Judgment 238 is also fueling another line of precedents which does not necessarily relate to immunity at all. And I am referring to the practice of invoking fundamental principles of domestic law to expressly disregard international obligations. This is a line of precedents, of course, that predates Judgment 238. You can think of the likes of the German Solange jurisprudence or Medellin versus Texas, but to which Judgment 238 has given new impetus. For example, this judgment was cited by the Russian Constitutional Court in a notorious 2015 judgment in order to justify disregarding judgments of the Strasbourg Court. And then a law was passed to this end, and we all know what happened. For the moment, let me focus on the first prong of this practice, the one concerning the so-called humanitarian exception. Many in Italy believe that Judgment 238 is indeed contributing to an evolution of state immunity, possibly in the form of a new norm, carving out an area of non-immunity where gross violations of human rights take place. However, I personally do not believe that Judgment 238 is actually contributing to the emergence of this hypothetical norm. And the reason can be found in what is to me the real key difference between the old and the current Italian case law on state immunity. In a passage of Judgment 238, which is paragraph 3.1, the court basically refused to question the content of international law as described by the ICJ in 2012. The court stated, I quote again, at the international level, the interpretation by the ICJ of the customary law of immunity of states is particularly qualified and does not allow further examination by this court. And then the court went on to challenge the content of state immunity purely on grounds of constitutional law. Now, as many authors have noted, for example, Focarelli, Cannizzaro, it is remarkable how counterproductive this passage was. Because even though the court wished to make state immunity evolve, through this passage, it contributed to entrenching existing international law because it expressed clear opinio juris in favor of the law as photographed by the ICJ. The court confirmed that the norm it was breaching was indeed customary and conceded that its decision violated international law. I believe there is a striking difference from the early case on restrictive immunity because those Italian courts affirmed that they were applying international law, even though they weren't, at least not from the start. They expressed both practice and opinio juris. Of course, here one may raise an objection. The objection is the Italian courts tried to use international law arguments in Ferrini. That didn't go well. So the Constitutional Court had to take another road in order to keep pushing towards the birth of a humanitarian exception. But this objection misses the point because it assumes that the jus cogens argument, as developed in Ferrini, was the only international law argument that could have possibly been employed to trigger an evolution of the law of state immunity. And perhaps Italian courts are still convinced that this is the case because they occasionally keep referring to that argument in current case law, besides the constitutional arguments taken from Judgment 3A. However, I believe that the court had other options to explore. Now, just to clarify, I'm not saying that the court should have looked for other ways of violating the ICJ judgment. I am saying that if its objective was to lay the groundwork for an evolution of state immunity, the court fired at the wrong target. It wanted to shoot at state immunity, but in fact, it shot at a different norm of international law, the one making ICJ judgments binding. So, a more effective way of influencing the development of international law would have been, perhaps, for the court to comply with the ICJ judgment out of its binding character, and at the same time, to contest in the reasoning part the description of international law made by the ICJ, so as to provide alternatives for future cases, a sort of dissenting opinion, if you wish. Trying to imagine what the court could have done in 2014 may look like a purely theoretical exercise, but in fact, it tells us what Italian courts may do in the future when the quarrel with the ICJ is finally over. Without going too much into detail for obvious time constraints, I'll just try to imagine now some of these possible alternatives, many of which have already been mentioned. One approach may be to erode the area covered by immunity by invoking or expanding already existing exceptions to state immunity. For example, the already mentioned tort exception. Let me restate that many believe, with very good arguments, and also Judge Gaia believed so in his dissent, that the ICJ incorrectly weighed existing state practice when it stated that the tort exception, if it even existed, did not apply to military activities. And we should recall that by all accounts, the tort exception also applies to acta jure imperi. Moreover, at least in cases involving forced labor, which are many, the Italian courts could rely on the so-called employment exception to state immunity. Of course, here, an obstacle may be, I still have to think this through, but an obstacle could be that employment rights may be considered to be time barred under the domestic legislation of the foreign state, but then it is the domestic time bars that should be declared unconstitutional, not the normal state immunity. An even bolder attempt may be to search for new ways to revive the so-called last resort argument, as again, Riccardo Pavoni mentioned. It is well known that the ICJ dismissed this argument by stating that it was not supported by state practice, concluding that international law admits no exception to immunity where an individual is left with no remedies. However, this passage is not entirely conclusive in my opinion. One could argue that state practice is not really relevant here, because this point does not concern the content of one particular norm of customary law, that of state immunity, but it concerns the relationship between two competing international norms, immunity and the right to a court. And reconciling competing norms falls within the ordinary functions of courts. Against this backdrop, an argument could be made that at least under certain conditions, the right of access to justice may sometimes be prioritized over immunity as a matter of international law and not of constitutional counter limits. This is, for example, what the Strasbourg Court has done for a long time as regards the immunity of international organizations, where it regularly applies a sort of last resort argument to check if immunity is compatible with Article 6 of the Convention. And of course, the leading case is Wade and Kennedy versus Germany. I have always struggled to understand, if international organizations' immunity, why not also state immunity? Those are just some ideas that show that in the glass ceiling of state immunity, there are many more cracks than Judgment 238 assumed. And this also shows that Italy's role in the evolution of state immunity is not necessarily over, assuming, however, that courts are willing to explore new paths. For example, again, as Pavoni suggested, focusing their efforts not on controversial wartime reparations, but on grave breaches of human rights occurring today, possibly in peacetime. But this is again about the future. As I said before, after the Constitutional Court dragged itself into a quarrel with the ICJ, the real main issue of the dispute was not really immunity anymore, but the binding character of ICJ judgments. And this is why, like a sorcerer's apprentice, the Italian Constitutional Court wished to change the law of state immunity, but ended up setting in motion something much less easily controllable, which is a challenge to the supremacy of international law itself. If Judgment 238's impact on future state practice will consist in making the use of counter limits mainstream, and this may be happening, we simply don't know yet, the international law of state immunity may remain exactly the same. But, as Conforti suggested years ago, we might be looking at the birth of a new circumstance precluding wrongfulness, one allowing states to invoke constitutional principles to disobey international law. And the 2015 Russian president, with its instrumental use of Judgment 238, indicates that this may be a very worrying development. And here's a final message for Italian judges messing with international law: be careful what you wish for, because it may come true. Thank you for your attention.
Thank you very much, Pierfrancesco, for these very thoughtful remarks. I will just point out one aspect, namely that those judgments in South Korea and Brazil that you and Riccardo referred to, they would both point to the idea that the tort exception is applicable in those circumstances, because in both countries, they were dealing, the courts were dealing with issues directly affecting their own nationals, or in any case, their own state. And while the tort exception may come in mind in that context, there is also the remark by Lord Justice Bingham in Jones versus Saudi Arabia, pointing to the fact that precisely this circumstance may render these precedents as Judgment 238 less heavy, so to speak, for the development of international law, precisely because of the direct involvement of interests of that state in the issue. But I would like now to open the floor to questions, remarks from the audience. I would just ask those of you who wish to intervene to present themselves, maybe, and also to keep in mind that we are recording the seminar and that we plan to publish the video of the seminar on our Macrocrime Center website. So just be aware of this if you wish to take the floor or to write down your questions in the chat. We will then have certainly a round of answers and maybe a possibility for the speakers to get in dialogue with the other on their respective presentations. Pietro, please.
Yes, thank you. Since there is already a question in the chat, I feel I have to at least try to address that question. My understanding is that the Italian government is not using the National Recovery Plan or any EU facility to provide resources to the fund we are discussing about. The only peculiar thing is that this provision on Germany is, for some reasons, inserted in a context that is simply not related to state immunity, to the ICJ, and so on. It might be that this is objectionable to some extent, but my understanding is that this is not, I'm not a specialist of constitutional law, but my understanding is that this odd thing is not enough to characterize this provision as subject to challenges in terms of constitutionality. One might wonder why the government inserted this provision, Article 43, in a decree that has to do with something that is completely different. One simple reason and rather innocent reason would be that this was the first opportunity, and instead of adopting a standalone decree devoted exclusively to this, well, the government seized the opportunity of the first available decree. This is an innocent reading and maybe not the right one. I have a feeling, I have no evidence of this, so it's just an impression that since this decree on the National Recovery Plan is going to have a fast track, a particularly fast track in Parliament, and is set to receive strong attention in terms of political parties in Italy will basically vote in favor, those of the majority at least, will vote in favor of these measures. Well, since they vote in favor of the remaining 49 articles of the 50-article decree, they will seize this opportunity to vote in favor of this very article. So maybe there will be, there's a chance that some political parties will not be happy with that, but the overall context of the decree is one that calls for prompt approval and prompt conversion of the whole decree into law. That's just a possibility. Thank you.
Yes, I would say I agree with your impressions and feelings on that issue. Yes, you read in the chat that Lorenzo Gradoni is also making some comments on this. I don't know, Lorenzo, if this is leads to a question, if you want to take the floor, but there's just an observation here about the decree law. Okay, anybody else wishing to take the floor or to raise a question? Antonio Leandro, please, Antonio, you have the floor.
Yes. Thank you very much. I am Antonio Leandro, Associate Professor of International Law in the University of Bari. And thank you very much for this very needed webinar. The matter is very complicated and all the more the law degree. A couple of reflections and a couple of questions about this decree. Apart from the underlying policies, the way of setting procedural and substantive restrictions to judicial actions aimed at protecting a constitutionally guaranteed rights poses at least one problem in terms of right of access to justice under our constitutional law, that the Constitutional Court will be called for surely to solve. But this is not the question that I would like to submit to you. The first is to Giorgia for her interesting remark as to the difference between indemnity sum through the fund and the amount of the judgment claim. Considering the judgment claim against Germany as a source of property rights in terms of Article 1, Protocol 1 of European Convention on Human Rights, in the event of a lower compensation, the party would have no chance of satisfaction in Italian law. There is no remedy as well. Perhaps there is room for an application to the European Court of Human Rights. What's your opinion about that? The second question is for Pietro. Do you see obstacles to enforce Italian judgment in foreign states? The law decree, not even the forthcoming law, could not theoretically exclude recognition in other states that may not allow immunity in such cases. And this may give rise some concerns, or at least hesitation, to Germany when deciding to withdraw the case before the ICJ. Thank you very much.
Thank you, Antonio. So, Giorgia, would you like to answer right away? And then
yes, of course, I will try. So, thank you for the question. I think that theoretically, this could be right. There could be the possibility to make an application to the court, but I'm not quite sure that an application will be done. Like, as I told you, I spoke with some Italian lawyers and all the Italian lawyers, they spoke, just two, of course, but give me an idea that all the victims are really enthusiastic of this fund. I think that, of course, their original idea was that they will never take some money from Germany. I have a close friend that was the nephew of a person that was victim of an international crimes. And I tried several times to say to him, okay, please, we can make a suit against Germany. But he decided to not present the claim because he said, okay, I will never see a single euro from Germany, you know? So now this idea that there is a fund that is a limited fund, in my opinion, give the opportunity also to the victim to say, okay, we can close the question. But theoretically, I agree with you, there could be the possibility that a perseverant victim says, okay, this is the moment to say that this way that was followed by the Italian government is not completely correct. There are some holes. Of course, there are some holes when there are some new ideas, you know, some, we can say this is a try, no, to do something. So theoretically, yes, there could be the possibility.
Pietro, and then we will answer. Off you go.
Yes. Very briefly on my side, I understand that since the judgments and prospective judgments will not be enforceable, and as of today they are not enforceable under the decree within the Italian legal order, this implies that they are not enforceable elsewhere under the relevant rules on the recognition and enforcement of foreign judgments. I do not know, Antonio, whether this answers fully your question, but please react if my answer is insufficient. Thank you.
Thank you very much, Pietro. We have a question by Hans Klein in the chat. Why did the Italian government suddenly decide to pay for German debts? Isn't that revolutionary? Do you think that this decree will hold in Parliament? Of course, I will try to answer that. I take this liberty. Of course, there is no certainty, but there is definitely a strong determination to settle the issue by the Italian government. So I think the Italian government seized this opportunity to close the matter, at least as regards Germany. And I think this will be perfectly understood by Parliament. Pietro already commented on the context of the decree law, which is more generally favorable to an adoption, maybe with some amendments that remains to be seen. But I think some form of, of redress will be provided eventually. in this respect, I also think that Germany's application will favor the adoption. Certainly, the request for provisional measures helps justifying the urgency of the adoption of this kind of measures. And I think the hope of both parties is that the problem will be settled, at least in the bilateral relations between Germany and Italy. That, of course, without impinging on the independence of the Italian judiciary. Riccardo, would you also like to comment? Then we go to Fabrizio's Marongiu's question also in the chat. Please, Riccardo.
If I may add to your comment, Serena, about what was said about on the chat about the motivations behind the decree law. Of course, as you said perfectly, we don't know exactly. And hopefully there will be some parliamentary debate about this during the conversion process. That's what I think that our government should tell us very transparently what are the reasons behind the establishment of this fund. There is an element in the decree which, for example, Lorenzo Gradoni assessed very comprehensively yesterday in his blog post. The decree law says that the establishment of the fund is in continuity with the 1961 Bonn Agreement. And that is a really interesting point, because we don't know exactly, but that wording makes us think that Italy is now accepting that the Bonn Agreement of 61 was really the final word in this matter, as Germany has always said. Of course, this would imply, as Lorenzo says, reneging on what the Italian government was doing during the first ICJ proceedings, because everybody remembers that Italy brought a counterclaim precisely on this issue during the first ICJ proceedings, claiming that Germany had not discharged its obligation of reparations towards Italian victims. So this would be a U-turn by our government. And I think that we would need some clarity in this respect.
Yes, I agree with you. And also, maybe it's worth noting that the Italian position as regards reparation has always been that victims should be entitled to a meaningful reparation, not necessarily to full reparation. And this is also in line with the Italian approach to reparation for breaches of the European Convention on Human Rights. So this might be an element to keep in mind when we discuss the problem of the amount of well, not necessarily compensation, of indemnization, let's put it this way. Fabrizio Marongiu Bonaiuti wanted to raise a question. And then we have Pietro Franzina, Giovanni Broggero, and Pietro, you withdraw, okay, then Giovanni Broggero and Andrea Saccucci. Please, Fabrizio.
Yes, thank you very much. Fabrizio Marongiu Bonaiuti, University of Macerata. Can you hear me? Unfortunately, I have no video because I'm connected through my mobile, because my normal connection through my laptop was not working properly this morning. My question has partly been replied by the follow-up of the discussion after Antonio Leandro's intervention. I was questioning effectively, in case the matter should come again before the Constitutional Court. This problem raised already by Giorgia in her presentation, concerning the difference between an indemnity as compared to full compensation as awarded by Italian courts in those judgments. Probably the question should be assessed in view of the practice to which also Serena Forlati was pointing to, the idea that as concerns compensation for international crimes, in certain cases not full compensation, but a sort of equitable compensation, like, for example, also in the practice of the European Court of Human Rights, might be the relevant standard. Maybe also would be more consonant with balancing, so to say, the constitutional goals from a strictly constitutional perspective. On the one side, the protection of the right of access to justice, Article 24 of the Italian Constitution, but on the other side, also the importance of preserving peaceful international relations and the observance of international law, pursuant to Article 10 and then 11 of the Italian Constitution. So probably a sort of balancing would justify this option in favor of a mechanism likely to provide indemnities rather than full compensation. That is my humble suggestion on the question which I would pose to the speakers in this respect. Thank you very much.
Thank you, Fabrizio. Who would like to answer maybe or react? Are there any reactions on this point?
But I can just quickly say, if I can.
Yes, please.
Yes, that in my opinion, before the decree, of course, the situation was completely different. Now with the decree, we know that our Constitutional Court, in a judgment of 2014, never expressly said the lack of alternative remedies for the victims was a condition, no, for its judgment. But if you read the judgment, it's completely present, this idea, no? The lack of alternative remedies is always repeated. So in this case, if we will have another problem of constitutional legitimacy, we must always take into account the words of our Constitutional Court in 2014. Now there isn't the lack of remedies for the victims. Now we have remedies. So I'm not sure that now the situation could be the same. Now something changed, no?
Indeed, this is so. The floor is to Giovanni Boggero.
So, good morning, everybody. I'm an assistant professor of constitutional law at the University of Turin. I would follow up to the question by Sara Tunani Ribeiro. I would say I would actually add some insights from a constitutional perspective. I pretty much agree with what Pietro Franzina said. Actually, there is a law, a state law in Italy, number 400, 1988, which concerning law decrees says that the provisions enshrined in law decrees should be specific and homogeneous. However, as a matter of fact, the Constitutional Court generally and also always took a very, so to say, restrictive stance on that, and declared unconstitutional law provisions in conversion laws rather than scrutinizing directly the law decree and the ratio of the rationale of the law decree itself. So as a matter of fact, when the government decides that a provision is homogeneous with regard to the content of the law decree as a whole, then it falls within its responsibility. And if the parliament decides to convert it into law, then the responsibility lies within the parliament. So I would say that there is no chance for declaring Article 43 of the law decree unconstitutional on these grounds.
Thank you very much, Giovanni, for your valuable insight. And now the floor goes to Andrea Saccucci. Andrea, please. We don't hear you, Andrea.
Hello, now you can hear me, I guess. Hi, good morning, everyone. Thank you, Serena. It was just a brief reaction to some of the comments coming from the speakers and the interveners, in particular about whether a challenge will be possible to the European Court of Human Rights with regard to this new provision. I think that there is an issue which mainly concerns access to justice and the very short time limit which is provided for in this Article 43, which is only 30 days, a time limit which is which basically forfeits the right of the victims to have access to justice for reparation, which is also quite contradictory, in my view, with the initial wording of the provision saying that the ordinary statutory limitation period are not being put into question. We are obviously talking about actions which normally would not be subject to any statutory time limitation. And therefore, the 30 days time limit is, in my view, problematic from the point of view of Article 6. And just to give you a bit of an insight I had from members of Parliament, I think that there will be a discussion in Parliament concerning also this point, this specific point, so the short time limit allowed for instituting new proceedings, and so the minimum that we can expect, I think, from our Parliament, notwithstanding the speed and the need for speedy approval of this decree, is that this time limit will be extended in order to allow victims to have an adequate time for bringing proceedings. And also, I don't know if I missed, unfortunately, the first part of the seminar, but so I don't know if this point was already mentioned, but I think the idea underlying the mandatory service of the lawsuit to the state advocate office is that then the state advocate will be able to propose a settlement. So we also need to understand what kind of settlement will be offered to the victim, and in order to assess whether then compensation will in fact be effective also from this point of view. Thank you very much.
Thank you very much, Andrea. I don't know if anybody wants to react on this. Pietro, please.
Yes, I would like to say something about what Andrea just said, and it's in the form of a remark and question to him. First of all, I also believe that the 30-day time frame is very short, and it's likely to be the object of discussion in Parliament. This is very sound. At the same time, I think there is a distinction that should be made for the sake of understanding this provision between periods of limitation, which are not affected, as Andrea said, by the decree, and the issue of admissibility of proceedings based on those claims. Prescription limitations are a matter of substance as understood by Italian law, whereas the admissibility of proceedings is a procedural question. I know that at the end of the day, it doesn't make much difference for the victim claiming something, but legally, the distinction should be taken into account in my view. Concerning the settlement, Giorgia raised the question earlier, and it could be interesting to get back to that. My understanding, it's true that it's not clear what the decree provides in this respect, but my understanding is that the settlement that is contemplated, first of all, it's just a possibility. The decree is there to say that the decree is without prejudice to the possibility of a settlement of disputes. My understanding is that the settlement should in principle occur between, if indeed is to occur, between the claimant on the one hand and Germany on the other. Am I wrong in that? And the purpose of the involvement of the attorney, the state advocacy, is that since the result of the settlement, so the settlement itself is a title for accessing the fund, well, there is an interest on the Italian part that the settlement is, so to say, supervised, because at the end, although the settlement as such is to be concluded between Germany on the one hand and the claimant on the other, it is the Italian fund that is going to pay for that settlement. So my understanding is that, and I do not know whether this is the right understanding, so I would like to hear from Andrea and from Giorgia whether they have a different understanding of that. Thank you.
Thank you very much. Before giving the floor back to Andrea and Giorgia, maybe Karin wants to comment.
Yes, I just have a small comment also on the decree, because I always ask myself, because there was not a limitation to those who have right for reparation. There are now far related family members of the victims, and it is sometimes difficult to see why they should be compensated or receive reparation at all. So I have always waited for a limitation of those having right for bringing claims of reparation for being members of a family, but there must be a certain balance. I saw judgments where a far related niece of a victim received in an Italian court much more reparation than a victim itself. And this really is a little bit strange for my feeling of justice. And therefore, I think after more than 70 years, it would be time to limit those who have a right to bring claims for reparation. Thank you.
Thank you very much. You're very right. The practice concerning compensation has been very uneven, and much depends also on opinions of specific judges dealing with cases. There have been judges much more careful to strike a balance, and others who were much more in favor of victims. Maybe also the approach of the Constitutional Court in 2014, as Giorgia mentioned, they relied on different arguments, never really choosing one or stating exactly how they were relevant, and not indicating anything about the amount of compensations. This could, also play an influence. But Andrea?
Thank you. Well, about Pietro's comments, I think they're completely reasonable. I agree that there is a difference, legal difference between statutory limitation and the admissibility requirement. But as a matter of fact, and as you yourself recognized, that doesn't change much from the point of view of whether there is a restriction on the right of access to court. And what it comes out of this provision quite clearly, in my view, is that the purpose of this 30-day time limit is to bar potential claimants from bringing lawsuits that they would then entitle them to have access to the fund. So to put a limit to the budget exposure of the Italian government in that respect. But in doing so, they are basically forfeiting the right of victims to have access to justice in the first place before Italian courts, which in my view may raise a serious issue, which certainly could be raised also before the Italian Constitutional Court, but we know that that would not prevent claimants from bringing directly their case to the European Court of Human Rights in such kind of circumstances. And about the settlement, the potential settlements, yes, in principle, the settlement should be between the claimant and Germany, but I think the idea is to have a sort of trilateral settlement in which the Italian state, through the state advocacy, will be directly involved, or or even an agreement between the fund and the claimant, which would then imply a duty for the claimant to abandon the lawsuit against Germany, for instance. So we will need to see how these settlement options will be arranged in practice, and whether the implementation decree will contain any relevant detail or provision about also this option.
Thank you very much, Andrea. And we have also a question in the chat from Luca Bayada. What about preventing war crimes and international crimes? Could we say to the victims of war crimes in Ukraine like this, please wait 77 years and then your family will receive a little amount from your own government? This is, of course, a very relevant issue. It's quite obvious, at least in my view, that compensation ex post is never satisfactory. The real challenge of international law today is prevention of international crimes. And precisely the conflict in Ukraine is a very clear indication of that. We cannot be satisfied with ex post court proceedings assessing that horrible tragedies have occurred. And I think we're all in agreement with that. Also, money could never compensate what happened then and what is happening now near our European family, so to speak, and elsewhere in the world, of course. Still, the principle that there is a right to compensation is an important principle. And I think, at least this is my personal view, that this step by the Italian government is finally saying we accept this principle to be a serious engagement for us as well, not only when we claim that others have done wrong, but we take up responsibility in a way. And this also maybe can help answering a criticism that was often raised as against judgment, the Italian judgments of 2014, namely about the inconsistency of the attitude of Italian courts that refused to consider on the merits claims raised as against the Italian state, for instance, for the bombing of the Serbian radio television station in 1999, because that would amount to a political act not subject to judicial scrutiny, and then go on to assess German responsibilities for crimes. Saying we are ready to pay for reparation is also a way to adopt a coherent approach to this issue of principle, which is very important, I think. And also, as about concerning the amount of compensation to be paid, this is a critical issue in international law more generally, how to assess individual damage in situations of extensive violations of international law. I think here as well, international law is evolving. I don't know what Karin thinks about it, but I think the recent judgment of the ICJ in the Congo versus Uganda case, pointing to the need for an equitable settlement, really, and not necessarily to payment of full compensation to each individual victim whenever mass crimes are at stake, is pointing to a direction which somehow is also followed by the Italian decree law. But these are just personal observations with no with no claim to be completely objective or truthful. So we also have a question by, I don't know if others have anything to say on this point, and then we go to Anna Liebman's question. I don't see any request to speak. So Anna Liebman asks, how do you think the relationship between immunity rules and the recognition of foreign decisions rendered against the state for violations of fundamental rights will evolve, given that in these cases, unlike when exercising jurisdiction directly and applying the territorial tort exception, states can exercise jurisdiction for acts not committed in the foreign state? Pietro, maybe, or...
I don't know. I think we will get back to the issue of immunity from execution, basically. although I acknowledge that this is probably a too short answer to satisfy Anna completely. Why don't we hear from Anna herself, whom I know is familiar with these topics. Anna, do you want to take the floor?
Please.
Apparently not.
So I
mean,
wonder
when the issue arises of the recognition and enforcement of a decision that is no longer jurisdiction to adjudicate that is at stake, so immunity to that jurisdiction is no longer at issue. But of course, the other immunity from enforcements will be affected. Yeah.
Thank you very much. I don't see any other requests to take the floor. Giorgia, Berrino, please.
Yes. Changing a little bit topic, we wait maybe if Anna decided to join. I have a question for Professor Pavoni. Before you talk about the application of Germany and the fact that Germany affirms that there isn't the possibility to enforce some judgment that are rendered against international law. So we say that this is a point, and we will see what the court in case will say about this. But Germany also says that there isn't the possibility to enforce against some goods that are that have public purposes, as we know. Now, my question is, considering what the Court of Rome said, so in particular the fact that with the second order, the court said Germany didn't prove the existence of the public purpose of the properties. Italy can use this argument as a defense before the International Court of Justice. It says that my judges analyzed the situation and said that there wasn't the proof that Germany, that these goods were used for public purposes. Of course, I agree with you that in this case, the public purpose is in re ipsa in the properties. But yes, the order of the Court of Rome said there is no proof. So, okay, let's move on. So I would like to know your opinion about this aspect.
Thank you so much for your question. It's actually a controversial and complex question. It's not easy to reply very, very rapidly, because I think that courts should always be given the opportunity to counter the submissions of parties. So I think that I can see anything wrong in the Canadian courts saying, actually, that cultural institution owned by Iran is not a cultural institution. They are using it to pursue illegal activities, for example, illegal intelligence activities, etc., etc. So I can see anything wrong about that. And if I was a lawyer for Italy, of course, I would advance that argument to say that there is no final conclusive evidence that that is indeed governmental property. I'm also saying this because there is another quite famous piece of Italian legislation, which I'm not sure that was mentioned before today. One of the first, I think it was the first reaction by the Italian government to the Sentenza 238. There was a provision actually immunizing bank accounts held by foreign states and international organizations in Italy as soon as the foreign state, the international organization, has declared to the Italian government that that bank account is used for public purposes. You say that Benedetto Conforti, commenting upon that piece of legislation in the Rivista di Diritto Internazionale, said that Italy was going back 70 years ago. because indeed that piece of legislation to me is not in line with our constitution. I do agree with Conforti, because there is no possibility for domestic courts to counter the arguments put forward by a state. So there can be a presumption of immunity, but that presumption is not an absolute presumption. I think that is fairly clear. And so I don't see that. I don't see that is the end of the story. If I may, if I can, I would like also to comment very briefly on the question asked by Anna in the chat, whom I unfortunately don't know her, but I think it was very interesting question about the relationship between state immunity and recognition of foreign judgments, something which was raised a few times this morning. Actually, I do agree with Pietro that when you're thinking about that, you're immediately thinking about immunity from enforcement, immunity from execution. But I would like to just recall that that was not the view of the ICJ back in 2012 in its judgment of 10 years ago, where the court said that when it comes to the recognition of foreign judgment, that is not an issue of immunity from execution, but it's actually an issue of immunity from adjudication. So the first question that the forum court should reply to is whether in a similar situation that a court would have granted immunity to the foreign state. So indeed, if I want to say, if I may go back to what I was saying this morning earlier about Germany's application, and I think that when Germany is saying that if the underlying judgment is rendered in violation of international law, then no measure of constraint whatsoever may be taken against state property. I think that Germany is perhaps referring to that part of the ICJ judgment relating to immunity from recognition of foreign judgments, and not to the part relating to the immunity of Villa Vigoni from measures of constraint.
Thank you, Riccardo. There are several raised hands. I think Andrea Sacucci's and Giorgia Berrino's are the old hands, maybe, and you don't. Yeah, okay.
Yes.
Then Karin, I think, and then Filippo. Filippo Fontanelli? Do you still want to speak?
No, I withdraw my request, like Germany. Thank you.
Oh, okay. Karin, please.
Yes, I think the question whether this is property used for government purposes in this case is really clear, because as I mentioned before, there was an aide-memoire of the Italian government of, I think, October 2021, where it stated and admitted that the 4 properties at stake are used for state purposes, not for commercial purposes. And so in this case, this question will not really be difficult to solve. As to the remarks made by the ICJ in the 2012 judgment on immunity from execution, they really did not go into details, but they said absolutely clearly that there is no possibility to make execution measures against non-commercial purposes used properties. That is paragraph 118 of the 18 of the judgment. And I think this would be at least one point where a new judgment of the International Court of Justice would rely on a solid basis and would really could not be really rejected.
Yes, indeed. I see a comment by Olivia Lopez Peña in the chat concerning the victims of the Distomo massacre, which obtained exequatur in Italy against Germany. Article 43 does not cover these kind of issues. Am I not wrong? I would tend to agree with you on that. It's very clear, I think, that the decree aims at targeting only a specific set of situations and not situations concerning crimes committed outside the Italian territory and not against Italian nationals. But yeah, I'm happy to hear other voices on this issue. Any other questions? If not, I would think that maybe a last round of spot interventions by our speakers could be appropriate, just by way of closing our very, very interesting discussion. As a last word, shall we go in the reverse order? So Pierfrancesco? Only if you feel you have something to add. It's not compulsory.
I just wish to thank all the participants for this very interesting discussion. I do not have other substantive arguments to add to the discussion, but thanks again for having me here and for this interesting conversation.
Thank you very much for your contribution to it. Riccardo?
See, also, I would like to thank you again for organizing this seminar and for inviting me. It's been a pleasure. I think it was an overdue seminar, webinar actually, because there was silence around the international law planet about this new case. At least yesterday, we found a blog post by Lorenzo in Agile Talk, and of course some posts by Pietro in another blog of the European Association of Private International Law. But apart from that, it's not discussed so much so far. So thank you for organizing this.
Thank you, Riccardo, for accepting to be with us and for what you said. And Giorgia, please.
Yes, of course. Thank you very much.
I mixed up. No, I didn't mix up.
Okay.
You were, yes.
So thank you very much for this seminar. It was a pleasure to meet you all virtually, but it was a pleasure. And just 2 points, because I didn't answer to Andrea Saccucci. So about the time for this new proceeding, these new claims, I'm agree with you. I was studying for other activity, for my lawyer activity, the law about the victim of Italian terrorism. That is a law of 2004. So now the situation, of course, is completely different, but for example, in that law, there is a provision that guaranteed the possibility to have access to some indemnity with different timeline from what is now the decree providing. So I'm really happy to know that there will be a large discussion about this aspect, as Andrea said. And I have also another point, but I just forget. So I think that was not so important. Yes, like the other point that I would like to underline is the possibility, that Germany will participate to this fund. This is a question. I ask myself if Italy, before the decree, start to speak with Germany to identify a participation of Germany. I don't think so. I think that Germany will not participate to the fund at all. But there is the possibility that in the future, if there is this settlement, there could be the possibility that Germany, as someone says, can change mind. So let's see what will happen. Thank you again.
Thank you, Giorgia. Pietro?
Just 2 quick points. First of all, I acknowledge that the issue of recognition and enforcement, which have been raised by Anna and by Olivia in her written remarks, deserve more space. It's a pity we have limited time today, but this gives a good idea for future events. And the second point, I would like, since you, Serena, thanked
What's the matter, Pietro?
Bad connection. Sorry for that. Okay, anyway, many thanks to the...
We hear you perfectly.
All right, good. So I just wanted to thank the speakers. Since you thank the speakers, well, also on my behalf, but I wanted to repeat.
So, Pietro, now we don't hear you at all. You are frozen on the screen. So, but I think I gather we all understood what you meant to say, and I would just give the floor to Karin, please.
Yes, I would join all the words of thanks in your respect, because it was really a very, very interesting meeting. And just a little remark on the question whether Germany will participate in the fund. That is, in fact, a question that is discussed in Germany. But I think Germany will not, because there were a lot of discussions and means to find a settlement. But Germany always said, with good reasons or not, I think with good reasons, that the agreement of 1961 were really the end point of reparation payments from Germany. This has been contested, but reading the terms of the Bonn Agreement really supports this meaning. So I think that there will not be any participation. And for the rest, I would be really happy if the settlement and if the payment by the Italian fund would finally really be realized, because the victims which have received a judgment according to reparation have to be treated in a fair way. And as things stand now, and that is 10 years after the decision of the ICJ, they have not received a single euro, and I think this is really not acceptable under no means. So I would really like it very much if there is a settlement. I would perhaps also like Germany to participate in the fund, but I am skeptical in this context. But at least for the victims and for those having been accorded reparation, this would be a very good outcome. Thank you very much once again.
Thank you all for participating, for taking the floor. I think we will have much opportunity to discuss further these issues in the next weeks, months, and possibly years. I don't know whether the case will go on, and in this case, Filippo and Fontanelli and Paolo Busco, whom I've seen also here, will have a lot of work to do, but still, the problems raised by these new developments and the idea that indeed the state of nationality of the victims may pay reparations, it's certainly not new, but I think can be an interesting, a promising development for the future, and also for cases that do not relate to old cases or old situations, but to much more hot, so to speak, problems, and I look forward to further exchanges on these topics in the near future. Thank you very much, all of you, and see you soon, I hope. Thank you.
Thank you, goodbye.
Yes, I should also thank Ilaria Pironi and Enrico Zannarini for their help with technical sides of this webinar. Thank you. Goodbye.
Thank you.
Goodbye.
Thank you. Goodbye.
Bye. Many thanks. Bye.